And as you said, we have invited some of the best scholars in the world, and Dr. Professor Matthias Leistner from Bonn University. You've promised to give us the outline of the European perspective, please.
Thank you very much indeed, Morten, for inviting me here. Thank you very much to the organizers. And thank you very much indeed, Morten, for mapping the area we try to look into today in such an funny, though comprehensive way. This very much fits with my presentation, since whereas you mapped the area in a brilliant overview, I would like to drill a little bit deeper with regard to one or two decisive issues from my point of view. And actually, I was told once that an English-speaking presentation always starts with a joke, while a German presentation, of course, has to start with a structure, with a Gliederung. So while that was my joke, here, of course, is my Gliederung, which basically will go along what Morten lined out in 3 steps. I want to have a look at what we already have in Europe, that is a lex lata under the existing and transposed InfoSoc directive, which already contains certain provisions on the research-related exceptions. Of course, I want to have a closer look at the Commission's package of September 14, 2016, which is currently under discussion, so we are all invited to improve that proposal, essentially, to the extent this will be possible in the policy process. And basically, from looking into these provisions or proposed provisions, I would like to derive a couple of key issues, which I want to discuss a little bit further, rounding up the presentation with some broader perspectives. Now, under current existing European law, we already have quite a comprehensive research-related exception. The problem with that exception in the InfoSoc directive is that it is a mere option for the member states. So while this sets an upper cap for optional exceptions or limitations with regard to research in the member states, it isn't a mandatory exception. And that's why, for example, Denmark is at complete liberty to not introduce it and basically bring all the researchers at Copenhagen University into the borderline to illegality. However, the ECJ at least has seen the problem and has improved that situation a little, because the ECJ, the European Court of Justice, has ruled that although all these exceptions are only options, if a member state chooses to transpose them, he has to implement them in a way which is compliant with the directive. That means, although a member state is at liberty not to introduce a research-related exception at all, if a member state chooses to implement a research-related exception, he will have to do along the lines of the Information Society Directive. He won't be able to do less. It will have to be consolidated along the lines of the directive, as there must be a consistent and coherent interpretation of these exceptions in European law. And with regard to possible reform projects, that's quite an essential bottom line of European law, because if a national legislator wants to introduce a national research-related exception, he will have to do so along the lines of the InfoSoc directive, and he won't be allowed to do less. So what are these research-related exceptions in the InfoSoc directive? That is namely Article 5.3a, the use for the sole purpose of illustration for teaching or scientific research, but that is limited to non-commercial purposes. Some interesting gray areas in drawing the thin red line between commercial and non-commercial here. It is, of course, quotation for criticism and review. We have that in most European member states' laws. And then it is an exception which basically tries to improve the framework for new digital uses, and that's the use of works in libraries or archives on dedicated terminals in these libraries for research or private study. So basically, the library or the archive would be allowed to digitize the material they have in the library and then present it in dedicated terminals on the premises of the library rooms for use for research or private study, on the condition that these works are not subject to purchase or licensing terms. So if there is a database which was licensed before, then the library wouldn't be at liberty to present it out with these licensing terms. And that led to a very interesting case which came from Germany, smaller university in Germany, Technische Universität Darmstadt. And that university presented the works on library terminals to the students. Of course, a rather intensive use by the students on these terminals. Plus, they could copy the works onto their USB sticks. So indeed, that was a rather intensive use possibility. And basically, the publishers argued in that case that at least they had offered reasonable licensing terms, and that for that reason, the library should rather have concluded a license than using within the reach of that exception to copyright law. And the ECJ basically decided that a mere licensing offer won't be enough to overrule that exception. So only if the library or the university has chosen to conclude a license, use will be governed by the terms of the licensing agreement, but the mere existing of licensing offers in the market won't be enough to overrule the exception. So basically, under the ECJ solution, the library would have the choice of whether to conclude a licensing agreement and then use under the terms of the license, or whether to use under the comparatively limited realm of the exception. Of course, from a publisher's viewpoint, that is a problem because that doesn't set incentives for concluding licensing agreement to the library, but still, that was a solution of the ECJ with regard to that limited exception. Plus, all the necessary acts of digitization shall be covered, and the users will be at liberty to copy the works in the library on the condition that it's for private use. And then the library would have to enforce that condition. I'm not sure of whether that is efficiently possible, so some problems for the publishers here, but we will see. I think all this would be more acceptable for publishers if they were given a fair compensation, basically a collective remuneration administered by the collecting societies. But that at the moment in German law and in European law is not a safe option because the sharing mechanisms between the authors and the publishers in that field at the moment are under a lot of discussion. So from the publisher's viewpoint, it is a little bit a problematic situation because they can't be sure to get a share of these collective remuneration incomes. I'll come back to that in a minute. And I would also like to draw your attention to one more ECJ reference, which is currently under review, and that concerns the rental and lending of e-books. So would a library be at liberty if it has 2 copies of a book to digitize that and rent it out, lend it out, 2 at a time in a digital way? That would be quite a far-reaching adaptation to the framework of digital use. Indeed, the Advocate General at the ECJ has proposed to treat that as normal rental and lending under the Rental and Lending Directive. So that would basically cover the rental and lending of e-books under the provisions of rental and lending in European copyright law. That would be quite a far step to adaptation of European copyright law to the needs of the information society. But as we see, all this is rather limited. Most of this isn't mandatory for the member states, and this brings us to the Commission's package of September 2016, Morten introduced to you. And indeed, the Commission's approach is rather limited. The Commission tackles the issue of text and data mining. It provides for a mandatory exception, new thing in European copyright law, mandatory exception, will have to be implemented into national law. However, it is a rather limited exception. It is limited to non-profit public interest organizations, so non-profit uses by a commercial actor wouldn't be covered. It's limited to lawful access, limited by the DRM measures Morten mentioned, and from my point of view, all this should be decisively broadened. Actually, from my personal point of view, and I know that this is shared by many copyright experts in the Union, these uses of copyright-protected material for TDM, to analyze it technically, let it be analyzed by computers or even robots, isn't a copyright use at all. Of course, you have to copy the work, but that's for pure technical reasons in order to extract the added value you want to extract from this. It doesn't really touch upon the expression of the work, which is the thing which is traditionally protected in copyright law. So from my point of view, this should be decisively broadened against the background that from a dogmatic, balanced viewpoint, this isn't even copyright use at all. This is mere technical reproductions needed for another main objective, which is far from the traditional copyright uses we know. Second limited mandatory exception is on digital and cross-border teaching. The Commission would argue that it had to limit it this way because only in cross-border teaching we have a single market problem and single market objective. From my point of view, I'm asking myself, why not just make the research exception in the Information Society Directive mandatory? That would basically solve these problems and be a broader, more wider-reaching approach. So this again seems too shy, too limited to me. And then there is a third exception on cultural heritage institutions, which would cover use out of commerce work by such institutions. Again, I'm asking myself of whether the limitations with regard to non-commercial institutions are really helpful here, because very often it will also be commercial players who carry out these activities in a more effective way at times than purely non-commercial institutions. So from my point of view, at least if this was done against collective remuneration, I don't see why it shouldn't be broadened considerably. As I said, the Commission's plans are comparatively, and from my point of view, too limited. But at least it is a first step to introduce significant mandatory exceptions into European copyright law. And at the same time, it illustrates a couple of key issues we will have to discuss when basically trying to improve these proposals. And these two issues are two issues which can be discussed against the background of our current German discussion on a possible reform of the research exception. So the German legislator decided to step forward, to even be faster than the Commission, and to try to reform our system of research exceptions before the new Commission's package will be enacted. And we have two main issues we are discussing. The first issue is of whether adequate licensing offers existing in the markets by the publishers would take precedence over copyright exceptions. That is, if there was an obvious, clearly documented, balanced, fair, and reasonable licensing offer by the publishers for their databases, should this rule out the use under the exception? And our current German viewpoint is that under a balanced perspective, as a general rule, it shouldn't, because this would have considerable chilling effects for the librarians, who would always have to check of whether there is a licensing offer in the market. And to be on the safe side, they would basically say, let's use that, or we don't know whether that is a fair and reasonable offer. It seems to be a strange package, it seems to be too expensive. But if it was regarded by the courts as fair and reasonable, we would be illegal using under the exception. So that would basically chill off the use under the exception. But then there are certain specific markets, and here the balance might be different. And that is namely school books, where basically one school book for a specific school or region, of course, has a monopoly, because for reasons of school, you have to use that very book. If you were at liberty to copy this under a research and study-related exception, this would destroy the very market for school book publishers. So there might be need for differentiation here. And of course, there will be a lot of discussion of whether we need comparable differentiations with regard to study books, because there's many law books you can study from, so that isn't a situation really comparable to the school books, but that is a very similar situation. Second key issue, of course, will there be fair compensation, that is a collective remuneration for the publishers as well? And from my point of view, of course, the publisher should have a share in the remuneration which is administered by the collecting societies. This should be shared between the authors and the publishers. There's a lot of discussion on that in Germany at the moment due to some lawsuits which were filed by individual authors, but this seems clear to me. And to come to the end, it might be interesting to look into how the Commission deals with these key issues. Well, the Commission basically avoids it. It leaves it open. The default rule is no priority for mere licensing offers, but there is an option for the member states to introduce this. Well, this wouldn't be effective harmonization. This doesn't really solve the issue. As regards fair compensation, the default rule is no collective remuneration for the publishers in regard to these limited, very limited exceptions. And I think for these limited exceptions, this is right. I'm not sure if there was a broader exception, whether there shouldn't be remuneration, but there is an option for the member states. And this is much too long to discuss it here. It rather goes back to the mapping exercise presented by Morten. We will have to discuss the Commission's proposal in the near future. We will have to think about the exploitation rights, limiting them in the case of TDM. We have to discuss these couple of key issues. And of course, and I can only mention this here, but we can discuss it further, we will have to think about the further regulation of open access publication. We have a very interesting provision on that in Germany, and if there was any question on that provision or on my point of view on open access regulation, I would be very happy to discuss it, but I didn't have the time to present it in my paper. Thank you very much indeed for your attention.
Ladies and gentlemen, Professor Matthias Leistner. And before you just, can I just ask you, you said fair compensation, a key issue in Germany. It's not a safe option as it is right now. Can you elaborate on that?
Yes, of course. The German system actually for decades worked quite smoothly. We had a rather broad catalog of exceptions in our copyright law, namely covering broad research and study-related exceptions. Of course, many people argue they aren't broad enough in the digital context, but they are considerably broad exceptions, in particular compared to the situation in Denmark, for example. All these exceptions worked on the condition that the institutions using would have to pay a collectively administered fee to the collecting societies. That is namely VG Wort in Germany for the individual authors. So the system was that in the context of universities, you would be at liberty to use, at least in the non-digital realm, and that the German counties, as the public authorities behind the universities, would have to pay a fee for this to VG Wort. And VG Wort, the German collecting society, would then distribute these fees to the authors and the publishers in a shared system which had been agreed upon in VG Wort. So there was collective discussions in that institution between the publishers on the one hand, the authors on the other, and they agreed upon certain shares, and then it was shared between these two parties. Now, the dogmatic legal problem with that in both German and European law is that the publishers don't have an own right. It's just the derivative copyrights they have, and therefore a huge discussion was incensed in Germany of whether it is allowed in the first place to give the publishers a share. And the German courts indeed decided that under current German law, since the publishers don't have an own freestanding right, all these sharing mechanisms, which had worked quite smoothly for decades, wouldn't be legal. It would have to go all to the authors. Now, on a short side, that is a very good solution. In a middle-term perspective, that would probably destroy considerable markets for academic publishing. So on a short-term basis, it would be better for the authors. In the middle term, some of the books wouldn't be published at all, and we would have a huge problem here. So the German legislator is about to adapt the law in order to to make these sharing mechanisms possible again. And there is a provision on that in the Commission's package as well. That's Article 13, which is specifically addressing that issue and enabling these sharing mechanisms to be continued in European law.
Thank you, Dr. Matthias Leistner. We will be discussing this. We might be looking into some of the same problems here in Denmark.